Yes. 9. Yes.
I've taken the consent, Your Lordship.
Can I take up this matter?
Hello.
Anyway, on the prayer of why?
Lordship, senior government advocate is appearing in this case. He is not well today, Your Lordship.
On the ground that the senior government advocate who is appearing is the matter is not well, is not putting well to the MS Professor Learned Counsel for the Learned Counsel appearing on his behalf. So matter may be listed after
After a week, Lordship.
we are not being objected to by Mr. Deepang Learned Counsel for the case. This matter after a week.
Another matter, Your Lordship, item 22, Your Lordship, with the same prayer, Your Lordship. Kindly take up this matter after 2 weeks, Your Lordship. I have to file affidavit in this case.
22.
Yes.
On the prayer of Abbess Arbasar, London State Council. List this matter after 2 weeks.
No, listed on 10th, Lordship, 10th November.
You will say,
Petitioner has con,
whatever, how to file affidavit,
yes, Lordship, I have to file
no
affidavit.
opposition on behalf of the state respondents. List on 10.
10th November, Lordship.
Madam,
Okay.
I'm praying for taking up of an unlisted bail application. Actually, item 4 is same accused person. The offense is also same. Only the thing is FIR is different. Yesterday we couldn't file because of technical reason. Item 4 is listed. The same applicant.
Item?
4. So another offense is same. FIR is different.
There's no urgency.
Just for calling CD, already this applicant, already one is listed.
Hello, Sip. I have explanation item number 34. On behalf of T. Taku, we have already filed affidavit in opposition and instruct me list this matter on 12th November 2024.
Objection?
No.
You want to file an objection in the IA?
Yes, Lord.
We already filed.
Okay, so why?
Leading counsel is out of session.
IA is for what?
Condonation
Condonation.
notice.
Yeah, one IA is for condonation and one is for substitution.
Okay. On the prayer, Mr.
BCBO.
Vishibo, Learned Counsel for the respondents list and prayer not being objected to by Mr. This okay, Learned Counsel for the applicant list this matter on
12th November.
12
12th November.
November 12/11/20.
Your Lordship, I beg to mention item number 36.
36.
My opinion will be of Nilam Taje, Connecting Council out of station.
Well, this wasn't the matter. What's the
I'm for the petitioner, Your Lordship.
are you ready?
Your Lordship, since they have some difficulties, so we can fix.
Otherwise, you are ready.
Yes, Your Lordship.
We'll hear the matter. Can you argue the matter?
No, Your Lordship, this matter is not.
Very short matter. Nothing. Very small matter.
Yes, Your Lordship. Yes, Your Lordship.
Small or big?
Small, Your Lordship. Since we are challenging the order passed by village authority.
Anyway, Mr. C. Logi,
No, Lordship, Sita jo appearing we have entered.
Learned Counsel appearing on behalf of Mr. Nilam Taji, Learned Counsel for the respondent on the ground that Mr. Taji, Learned Counsel has some personal difficulty today. Press for listing of the matter. After
3 weeks.
3 weeks. 3 weeks. Mr. Prayer not being objected to by Mr.
J. Singh, Your Lordship.
J. Siri, Learned Counsel appearing on behalf of Mr.
Ketama.
Ketama, Learned Counsel for the petition. List this matter after 3 weeks.
Your Lordship, there is an interim also that may be continued.
Interim order passed and there's continue.
Much older.
Highly apply.
My Your Lordship, I beg to mention item number 32, Your Lordship.
32.
Yes, I'm appearing for victim, Your Lordship. Here, I'm appearing for victim, Your Lordship.
Yes.
We need some more time to file our affidavit, Your Lordship.
So it's service is complete.
Lordship, we are
maybe
agreeing.
listed for this one. We'll see why this is listed for.
Noted.
It's okay, on the prayer of MS,
Tirimi.
learned counsel appearing for respondent number 2.
Yes, for victim.
Yes.
Yes, Lordship.
Why this has been listed today? Nothing. Respondent number 2. List this matter after
After 3 weeks, Lordship.
3 weeks.
So interim may be continued.
Interim order passed earlier, sir.
God bless you.
Mr. J. G. learned counsel for the petitioner is present.
May I please, Lordship?
Yes.
Lordship, I beg to mention item number 11. Lordship, I am for respondent number 7. We have filed our affidavit, though today the counsel for the petitioner, T. Tagomi, is out of station. And moreover, for
So
respondent,
you are mentioning on behalf of Titago.
yes, also counsel for the respondent 7, please, senior counsel is supposed to appear, but he could not, Your Honor. On behalf of PJC.
On the prayer of Mr. K. Lowland, then counsel for the respondent
Yes, Lord.
number
7.
7.
Yes.
As consented by the learned counsel for the petition, let this matter be listed after,
Can it be on Lordship 18?
listed on 18/11/2025. Mr. G. Tarak Learned, standing counsel, the RWD is present.
Item number 1. May I please, Your Lordship? We seek to hear His Lordship, the non-registration of FIR.
Where the FIR? Have you filed the FIR?
It was filed, Your Lordship, which is, I have annexed as annexure 11, page 80,
80?
page 80.
80.
Before the concerned officer in charge. And thereafter, I have approached before the,
What is the offense you are alleging?
this is pertaining to Your Lordship work. Here the respondent, number 9, who has submitted a bank guarantee, which amongst the departmental communication to the concerned bank authority. Later on, the bank has confirmed.
You are alleging forgery.
Yes, Your Lord.
Under which section? Offense?
Will come, Your Lordship, for now new sections will. Earlier 461, 471, which section is forgery.
Is it a cognizable offense?
Yes.
Cognizable offense.
Not public.
It appears to be arisen out of your tender and all those things. Wow.
The internal communication which revealed, clearly reflecting that there is that bank guarantee which they have submitted was forged.
Anyway,
And to cover-
heard Mr. A.K. Singh, learned counsel for the petitioner.
My lord, here
But-
whether the writ will be maintainable for registration of an FIR,
Yes,
maintainability of this petition itself. M. Subramaniam and Sakarni Basu case, my lord.
no issue notice, we are not passing any order.
Should notice may be issued.
We'll see.
Only the maintainability.
Claiming that the FIR lodged by the petitioner on 03-10-2025 has not been registered and no investigation, registered and no preliminary inquiry has been undertaken by the police, this writ petition is filed seeking the direction for constitution of special investigation team. Now, no, seeking registration of the said FIR and also for a direction to constitute SIT, special investigation team, or to transfer the investigation to an independent agency. This writ petition is filed. Issue notice returnable by 4 weeks. As Mr. N. Ratan, London Additional Advocate General enters appearance on behalf of
1 to 5.
respondent number 1 to 5. No permanent notice need be served. However, extra copies be furnished to the censor. The petitioners to take steps for service of notice upon respondent number 6 to 12, 13. Whereas that for so-and-so.
Okay.
Appears to be a dispute with regard to business, purely business rivalries.
Non-cognizable minor.
It's not cognizable offense. We'll see.
Item number 2.
Madam Priscilla. My lord, in this matter, we are challenging the impugned order dated 8/8/2025.
Where it is,
This is at page 30, man.
13, 1 3
30.
30.
Yes.
What is this?
Madam, today, present case is fixed for appearance of accused person and for examination PWs, two accused person, namely, Likata Gankipa Achung represent, along with the learned DCs, states the represent by such and such. Witness is present. He is examined as PW 22 and discharged after due cross examination. Issue press summons to such and such. It is up here, madam. It is observed from record of the case that accused Kipachung has accepted the tender of pardon, accepted to be approved, and his deposition was already recorded by the magistrate. However, during his examinations PW6, he has not divulged the truth which he had already deposed before magistrate, and accordingly he has violated the condition of tender of pardon. Accordingly, another proceeding under section 308 CRPC required to be drawn against Kipachung, that the relevant records this order granting pardon to the accused person, his deposition recorded by magistrate, and his deposition recorded by this court as PWC forwarded to Honorable Guwahati High Court for providing sanction for prosecuting the accused, namely Kipachung, separately for commission of offense of giving false evidence. Well, first of all, the under 308 CRPC, the first condition is that to initiate that proceeding, my lord, a certificate from the public prosecutor is mandatory, madam. May I read the section 308? Trial of person not complying with condition of pardon. Where in regard a pardon who has accepted a tender of pardon made under section 306 or section 307, the public prosecutor certifies that in his opinion such persons has either by willfully concealing anything essential or by giving false evidence not complied with the condition on which the tender was made. Such person may be tried for the offense in respect of which the pardon was so tender or for any other offense of which he appears to have been guilty in connection with the same matter and also for the offense of giving false evidence. The condition precedent is, my lord, a certificate should be issued by the public prosecutor.
Yes.
And lordship, what happened, the tender of pardon was given in 2007, my lord. My lord, kindly see, just before that, my lord, page 29.
Yes.
My one more thing, my lord, page 29, my lord, kindly see page 29 also.
29 is what?
My lord, this is the, in 2018, the learned trial court, my lord, had directed the present petitioner to be tried as an accused person, my lord.
You are not challenging this.
No, my lord, no, I'm not, your lordship may kindly see, no, in view of the provision of section 30 CRPC, Kipa Achung approvals shall be tried along with Likha Thakur as co-accused. This is the order passed in 2018, my lord. Now, in 2025, my lord, how the trial court must suo moto take a different view of his predecessor and, my lord, suo moto take an action without any
No, you are being tried as a accused.
Yes, trial, it started in 2018, my lord. And after 6 years, now this learned court is, my lord, reviewing his own order, which is not permissible in the criminal proceedings. And certificate, my lord, that's the first condition that has to be satisfied by from the public prosecutor. No any
But
certificate
this
was
is,
issued.
for
Suo moto action was taken.
another president seems to is required to be drawn against so and so for giving false evidence.
That's why, my lord, who should certify, my lord, whether the person has given false evidence or not? The public prosecutor, my lord. It is public prosecutor should give a certificate stating that this person has given a false statement. Then only the court can take the action, my lord.
My lord, the first issue is, my lord, it's a revision petition, so victim has to be impleaded. Now, the second part, so far as merit is concerned, my lord. Here, your lordship, in Annexure 5, my senior has pointed out page number 29, my lord. Here, public prosecutor has clearly stated before the court that on the condition basing on which he has been pardoned, that has been violated, my lord, which is mandated under 308. And in 308, my lord, there is two parts. The first part is the person whom has been tendered pardon for the particular offense, my lord, he can be tried for that offense. And second part is for giving the false statement. And for false statement, my lord, the sanction of the High Court is required, mandate, my lord. But for the first part, my lord, for that part, my lord, on page number 29, they have annexed, my lord. That part, that has not been challenged, my lord, as on that, my lord.
That's what I'm saying. It's only for giving false affidavit, false evidence.
Yes,
For the second part.
yes.
when
And
the
for the
of
sanction
the
is
High
required.
Court is required.
Any sanction is required from the
happened? What happened? Any idea?
No, my lord.
This is of August.
Yes.
Any sanction has been granted, given
date-
by the High Court.
Till date, my lord, I don't think because there was.
Just issue notice.
My lord,
Yes, ma'am.
the order may be stayed, my lord. Prima facie, my lord,
No, we don't
don't-
know today. If the sanction is granted by the High
Yes.
Court, we'll see. We'll see. Call for the records today.
yes,
Otherwise, you are being tried as an accused.
yes.
We'll see.
We are not challenging that 2018 order.
Yes, that's what I'm saying.
Yes,
And he's rightly pointed out, it's that part is as an accused
yes,
in that the
We are not
offense,
challenging.
offense. There's no issue.
Yes.
All right.
no.
There, according to him, the public prosecutor has given an this
No,
certificate.
no certificate was issued.
Whatever. You are
Yes.
not challenging.
Yes, no,
Now this is another
yes,
another proceedings for giving false evidence
Yes.
which is required to, sanction is required from the High Court. We'll see.
Madam, for the
Call for the trial, scan copy, what's
Yes.
happening now.
My lord,
Otherwise, my lord, once if it's not state, my
No,
lord,
if
then-
once High Court sanction, we'll
Yes.
see. We'll see, we'll call for the record.
and without sanction, he will not be prosecuted for that
Yeah.
offense, my lord. And my lord, 442 mandate has to be complied with, first of all, my lord. The victim has to be implicated because now he's an accused, my lord. It's a revision petition, my lord. Not a
You file your objection, we'll see, we'll call for the record.
my lord, that mandate by the provision itself, statute itself, my lord.
It's
My,
all right.
my lord, may kindly come to 442, my lord.
What do you
BNSS.
say? Technicalities, you implead him,
yes, ma'am.
implead. Withdraw, press file, implead him.
Four forty-two,
It's a
subsection
302.
two.
It's a 302.
Yes.
302.
Yes.
442 of what?
442, my lord, BNSS, my lord, revision, my lord. And requirement is under subsection two, my lord. Two.
Powers of revision.
Yes, ma'am. My lord, may kindly directly come to subsection two, my lord. No order under this section shall be made to the prejudice of the accused or other person unless he has an opportunity of being heard either personally or by advocate in his own defense, my lord.
Where it is?
My lord, subsection two.
442.
Yes, my lord.
No order under this section shall be made to the prejudice of the accused or other person unless he has an opportunity to bring up the victim.
So in this case, madam, government is the, madam, state is the prosecutor.
No, no, no.
In the case of any fiscal effect or change in conflict, secretary is responsible. We're not passing any order which will be prejudiced.
Yes, my lord.
You may implement later, you implement later.
Yes, in the meantime, he can.
You may implement. We're not passing any order today. All right?
Yeah.
Heard Mr. Peter Putland, counsel for the petitioner. By filing this criminal litigation petition, the petitioner has put to challenge the order that is 0808-2025 passed by the Maryland Sessions Judge. In Sessions case number 10 of 2020 and section 120B, page 30, page 6.303034 of IPC. So the petitioner is sought to be proceeded with another proceedings under section 308 of CRPC. Sought to be drawn another proceedings under section 308 CRPC against the petitioner for commission of offense, separately for commission of offense of giving false evidence, which has been furnished, has been forwarded to the Guwahati High Court for providing sanction for prejudicial mistake. Call for the case trial court. Scan copy of the trial court record. Scan copy. Mr. Learned additional people. Enters appearance, accepts. Enters appearance on behalf of the state. Next para. Petitioner may file an appropriate application for implement of the what do we call it, persons. Victim,
Yes, my lord.
say accused or the other person.
Other person include victim, my lord. It's a broad
Other
term, my
person include the victim
Yes, ma'am.
and the victim and other person, accused and the other persons, including victim.
The complainant only, the victim is no more one.
Okay, it's a 302. Complaint oblique informant. Sorry. List after 4 weeks. 4 weeks.
Sorry, my lord, in item number one. One more observation we have to make about it. It's two under maintainability.
Ah, item 1. Sorry, since he has already, as since the learned additional advocate general has raised the maintainability of the present petition and the maintainability of the petition in the present form, same shall be considered on the next date.
Public.
Item number 3.
Please, ma'am.
Yes.
My lord, here I'm putting to challenge the proceeding in the title suit that is going on and the order by which that title suit was filed.
Where is the order?
My lord, the order is at page 16, ma'am.
18 or 16?
16.
This case.
My lord. Yeah, my lord, that after the initial that the first title suit 3 of 2025 that was withdrawn pursuant to the settlement between the parties. Now, after the withdrawal of the suit, this missed case was filed for restoration of that original title suit, that 3 of 2025. Now, we were never served any notice. And without hearing the petitioner and who was respondent therein, defendant, the court came to the finding that there was some mischief in withdrawing the title suit. And
Okay,
as such,
heard Mr. Learned counsel for the petitioner. This civil revision petition, despite challenging the order dated 2208,
22(8) and the
2025,
summons as well, summons and the order in the new
and the
title suit.
consequential summons public orders dated 150720. No, this,
No,
where
that
is
is the
where is the summon?
summons is at my lord, page number 14 and 15, my lord. 14 is the order, my lord.
Summons oblique
14 and 15, my lord.
order dated
16/9/2020.
16/9/2025. And
The summons is at page 23/9/2025.
same date, no?
No, this is 23/9/2025, my lord.
23,
Page 15.
9/2025. Whereby the, no, you said the summon and it will come later, huh? You just delete that summon and order and summon, huh? Second part. Whereby the title suit number
The
first passed in by the civil judge senior division Daporizia, passed in Miss within bracket J bracket close case number 09 and 2025 in title suit number 03/2025, whereby the what is the title suit?
title suit number 3 of 2025, the first title suit.
Or the title suit number 03 of 2025. which was withdrawn has been restored, huh?
Not,
Restored.
not restored, my lord. Liberty was given to file.
Whereby the respondents have been, respondents
My lord,
have been given liberty to file a fresh suit
press.
in the respect of the subject matter. No, fresh suit in respect of the title suit number 03 of 2025, which has been withdrawn by the parties, huh,
Party.
on the ground that some mischief might have been committed by the plaintiff number one in withdrawing the said title suit. Huh? List of the petitioners also challenges the consequential order dated. What is that order?
Page 14, my lord.
14.
Is the order in the new title suit, my lord. And the summons it. This is a fresh title suit.
Order passed in title suit number 06 of 2025. And the summons dated 23/09/2025. List of next para. It is the contention of the Mr. D. Sokilan counsel for the petitioner. Petitioners, one or
One only.
petitioner, that the title suit being TS number 03 of 2025 has been withdrawn by the respondent number one or what? No, plaintiff number one.
Yes, ma'am.
After what?
After settlement, my lord. That is order is at page 18, my lord. That withdrawal
In
order.
respect of the land, what is the name of the land? PAB
Power
B,
Modi.
Baba Modi, under Giba Circle, after settlement between the parties. Mr. However, the learned civil judge, senior division, the Parijo has allowed the respondents to file fresh suit being title suit number 06 of 2025 without hearing the petitioner.
Ma'am. It's otherwise it's in the reflected in the order itself that the dependent, the petitioner herein is absent. In the order of 22/8/2025.
Issue notice returnable by, for which and then counsel for the petitioners to take stage for submission notice upon respondents
Respondents.
registered for so and so. Next para. Considering that the title suit which has been withdrawn by the parties, title suit which has been withdrawn, title suit being, no, title suit which has been withdrawn by the parties after the settlement, and also considering that the impugn order has been passed, which culminated in the filing of fresh title suit on the same subject matter without hearing the petitioner. I deem it appropriate to. I'm of the considered with that an interim order is called for accordingly. The further proceedings
Further
of the
proceedings, ma'am.
title suit being TS number 6 of 2025 shall remain suspended till the return of the date.
Deep blue.
Item number 4,
Heard Mr. So-and-so, MFL and counsel for the petition. This is the application under section 483. BNS so and so, under section, for praying for release of accused, name of the accused,
Sridham Burman,
Sridhar,
Burman,
Sridhar,
Dam.
Sridhar Burman, on bail in connection with sections and in connection with
Oh,
Itara.
accused is Sagar Burman.
Ah,
Accused is Sagar Burman.
namely Sri Sagar Burman,
Yes.
in connection with what
Ita PS case number
Itara PS case number
102 of 25.
102 of 2024 under section.
111.
Take it from here. Page 1. Call for the scan copy of the case diary.
Yes,
Case diary.
yes, yes, that.
Mr. Jitado Learned Additional PP appears progress. List after a week.
My lord, it can be listed Friday. Because from tomorrow, default will start.
Huh?
It's the 19th day of,
Huh?
charge sheet has not been filed yet. Today is the 19th day. From tomorrow, default will start.
Okay. Next week, Monday.
Monday.
Obliged.
And
And unlisted
Same
matter is connected.
Same order in item. Is the accused, name of the accused here?
yes, same person.
Same person, different.
Different FIR.
Ah,
Offense is
FIR is,
FIR is
or PS case number?
Doimuk PS case number.
Doimuk PS case number?
Doimuk PS case number. One zero six 25.
106 of 20, under section, same section. No. You take it from there, huh? Then item 4. Don't, Yama, don't make a mistake. I'll take it from there. Different. Name different. Police station different. Sections different. Then,
They are also CD.
Huh?
They are also CD.
same order. Yes.
Obliged.
Monday. Give the date. Monday is what, 3rd? Yes, next. 5.
May I please, my lord? My lord, we have detected some defect in the application. We may be allowed to withdraw the application and file a
What defect?
in the course titles.
MS M. Karbak, learned counsel for the applicant submits that she may be allowed to withdraw his bail application with a liberty to file press as there is certain as there are certain mistakes in the petition. There are certain inadvertent mistakes in the petition. Whereas allowed this the bail application stands close on withdrawal with the liberty to file press. Yes.
Item number 6.
My lord,
Husband and wife.
husband case, my lord, this is an application under section 482 BNS 224, grant of pre-arrest bail in connection with Yazali PS case number 09/25. Under section
Offense.
8, offense
Offense committed.
86.
Place of occurrence is Nirjuli.
Yes, lord. So they have the informant has filed at Yazali.
Anyway, it's a husband and wife, madam. Interim. You appear within 10 days.
Lord,
Is there any seriousness?
There is a section of attempt to murder.
Where is husband and wife?
Lord. This is domestic.
Sir,
issue, Lord.
However,
I am
your
going to
Lordship,
settle it very soon.
You appears to be a little arrogant.
No,
Love
since
your,
police is chasing me,
love your wife. You have a kid, small kid. You have a kid.
yes,
You have a child.
yes.
How old?
All that's the
2.5 years.
3 years and above.
Huh?
3 and above.
Your application says 2.5 years. Am I correct? Or am I wrong?
Age is not mentioned. Child age is not mentioned.
See,
Minor.
your fight will, I mean, the child will suffer because of your fight.
But
Settle the matter. What's the,
Lordship, sure.
if you are, if there is any incompatibility or irreconcilable between you, There's a process.
Yes.
Why to fight? Why
Yes.
to make an attempt to murder?
Not exactly, not any such offenses committed by me.
Ask
Since this-
Mr. Arnabam,
That's it.
learned counsel for the applicant. Next para. This is an application under section 482 of BLSS 23. Praying for grant of privilege of pre-arrest bail in connection with Yazali PS case number 09 of 2025 under section 82, 86, 116, 109, 351 BNS, 2023. Next para. Call for the scanned copy of the case diary. MS T. Learned addition PP. Appears for this. The state, huh? Next para. What is this section?
So section
Attempt to murder.
is 109, Your Lord.
Uh, although a serious, although an offense under section 109 of BNSS has been registered against the applicant, accused applicant, considering that the respondent, the applicant, accused applicant and the informant are husband and wife, I deem it appropriate to grant interim bail, considering the facts and circumstances of the present case list of accordingly. In the event of arrest, the accused applicant shall be released on bail and furnishing a bail bond of rupees 20,000.
Lots of 10,000. I'm a very poor guy.
You are working in the.
I'm a casual labor.
You are in a nationalized bank,
Casual staff.
working in the SBI.
Lots of casual staff.
Okay, 10,000
10,000. Lots.
with one serious of like amount to the satisfaction of the arresting authority on the following conditions.
Much
The accused applicant shall appear before the investigating officer within 10 days from today.
lots.
Petitioner shall, the accused applicant shall cooperate with the investigation. Next para. Third word that condition you added, including the petitioner, accused applicant shall not communicate,
Yes, with the
Informant.
complainant.
Huh?
Informant, Your Lord.
complainant, informant.
Lots. I will abide by.
Don't pretend.
Item number 7.
My application.
Yes, sir.
My lord, in fact, the matter is pertaining to the education department.
Yes.
So this morning only I came to know that the standing council of the education department is out of
Yes.
district.
If the standing council is out of station, is it a rule that
No.
it should be automatically,
No,
should
no.
be automatically adjourned?
Otherwise, my lord, so far, the actions of pleading in the present
Everything is
case.
complete.
No, my lord, not completed.
Okay.
We failed to, my lord, evoke the response from private respondent. That is respondent number
Private
6.
respondent is appeared.
Yes, my lord, not appear. Therefore, my lord,
Notice is complete.
notice completed. So, my lord, one order was passed on 13 February 25.
Yes.
Whereby, my lord, the registry was directed to confirm whether the service upon respondent number 6 has completed or not.
Affidavit in reply not yet filed. Have you filed the affidavit in reply?
Yet to file,
Then you want some time to file.
my lord. But, my lord, one thing, my lord, whether the service upon the respondent number 6 has completed or not. Because, my lord, we have
Yes,
taken
that-
thrice.
On the service upon respondent is completed by the office note dated 5 is yes. This is completed.
My lord,
7/5/2025.
my lord.
Heard C. Modi, learned counsel for the petitioner. Affidavits in opposition on behalf of the respondents. State respondents.
Yes, 2, 3, 4, and 5.
have already been filed. Mr. Herbert. Neither the petition, respondent number 6 is represented, nor any affidavit has been filed despite service of notice as noted in, when or noted as per the 0705 office order dated 07/05/2025. On the ground that London Standing Council, Mr. T. Tangum has personal difficulty today. As prayed for by the party, let this matter be listed after 2 weeks for admission.
Item number 8. Your Lordship.
Yes,
Your Lordship, here the private respondent is required to file.
yes. So what is the matter?
Because there's a challenging the impugned order passed by the Deputy Commissioner Isian in the appeal case.
Okay. What Mr.
J. Karbak.
J. Karbak, Learned Counsel for the J. Karbak, Learned Counsel for the petitioner. You have also filed?
Yes.
Mr. Vairiram, Learned State Council submits that he has already filed the appeal on behalf of the state. Mr. Omodi, Learned Counsel appearing on behalf of respondent number 4. Submits that he has filed his affidavit on behalf of respondent number 4 this morning. According to this matter after 3 weeks. 3 weeks.
Yes. And Your Lordship, there is an interim order of it.
File. The file affidavit in reply, if so advised. The interim order passed and they shall continue.
Obliged. Item number 10.
Ma'am, hello. In this, we need time.
Second consent. Need time for what?
Leading council, GBAM is out of it.
Huh?
GBAM is out of it. On behalf of.
Not Mr. No, Mr. So-and-so, Learned Counsel appear. Your name is not there.
No, Your Lordship. I'm on behalf of RSOI.
Learned Counsel appears for respect, that RSOI Learned Counsel for the petitioners, huh? On the ground that Mr. G. Bam has some personal difficulty today from Mr.
T comes.
T. comes Learned Counsel appearing on his behalf, appearing for the respondent's press for listing of the matter after 2 weeks.
2 weeks.
3 weeks.
2 weeks.
2 weeks.
Much of.
Item number 12.
Lord, I have deep reflection yesterday about all the queries that my lords put me in that case, my lord. As an officer of the court, I have to be fair, my lord. When something is wrong, it is wrong, my lord. And when my friend is right, is right. Lord, I, as an officer of this court, I can only make a submission that this is an international commercial arbitration, my lord. I cannot shy away from that. My friend is right, my lord. I leave it to my court, to this
You have
honorable
filed-
court.
Who has filed the section 9?
My lord, I have,
So we'll give you a liberty to withdraw,
my lord,
withdraw and
I have no problem, my lord.
avail the
Yes,
appropriate remand.
My lords may kindly
Because you have-
record,
your-
my lords may kindly record.
Ah.
I leave it to my lords to pass any appropriate order, subject to the fact that this is without prejudice to my rights to
No,
pursue. That can be
we
recorded.
cannot disturb you.
Of
We
course,
cannot disturb
that
you.
may be recorded, my lord.
Okay.
Ah.
So sort order in that case.
Yes,
You don't have
yes,
to
my
go
lord, yes.
into all these
But
things.
my lord.
Huh?
Oh, this I cannot withdraw. This is
No, no.
your appeal.
No, not appeal.
Yeah.
My lord, it can withdraw before your lordship.
No, this cannot.
No, I cannot.
It has to be withdrawn from the.
Your lordship stayed in the other matter, the proceedings before the section 9 part.
No, no, no.
See,
That
what we'll
one,
do is-
with this
what-
order, we
see,
can go and withdraw it.
Yes, what we'll do is, on the ground of jurisdiction,
Yes,
as
my lord.
clearly admitted, submitted by the Mr. Henry, will dispose of, you allow this petition.
Please, my lord, please, my lord.
Will held that,
Set.
will say that, the appeal under section 9 is not maintainable in view of the so and so, so and so.
Please, my lord, please. my
Petition
lord.
under section 9.
I say petition under section 9 is not maintainable, therefore, it is.
And my lord, that particular recording has to be that without, this is without prejudice to my rights.
Yes.
Yeah,
You
yes,
just
yes.
simply say they will give you a liberty
Yes.
to approach the appropriate,
Yes, yes.
to avail the appropriate remedy.
Under the appropriate law, before the
Under the
appropriate
law.
forum, my lord.
That's all.
That will suffice, my lord.
Ah.
I have to be very fair to the
Okay.
court, my lord.
Thank you, thank you. Well, I'll pass the order,
Please, my lord.
all right?
But then your lordship set aside the order.
Of course, of course.
Obviously.
Yes.
Without jurisdiction, how can?
Yes,
Please, my lord, please, my lord.
I'm so blind, your
Ah.
lordship, patient hearing.
So we'll, in that case, we'll say, without jurisdiction, so we'll set aside.
Yes.
And
And
we'll say that the section 9 application is not maintainable at all.
Please, my lord.
Ah.
Please, my lord.
Then formally, once. it
Yes,
is
yes,
set
it's
aside,
just a formality
once
after
set
that, my lord.
aside, may formally withdraw the
That's true.
section 9,
Please, my
all
lord.
right?
I'm so blind, my lordship, patient hearing. But yes.
No, it's okay. I'll pass the order.
Till 5 o'clock.
I'm so blind.
Could have finished yesterday.
I wanted to, but then I also wanted to have a second
You
thought
want,
about it, Lord.
you want us to have a more hammer from the Honorable Supreme. Bigger hammer.
Uh,
No, it should be, this is the, I mean, we call it, this is the way out.
My lord, I remember when my lord was on this side of the, I remember my lord was very fair.
Has to be.
I
All
have
of
to be fair as an officer of the court,
only-
especially in this court.
Not only, all of us has to be.
Please.
fair. Yes, yes,
Please, my lord.
yes. Thank you.
I'm so blind.
Grateful, my lord.
Ah.
Obliged.
Matter number 13,
Dispose of, huh? Yes,
This is my regular second appeal matter. And
first time,
first time, my lord.
we'll issue notice,
Madam.
right?
Yeah.
Heard Mr. Learned Counsel for the, appellant,
Appellant, my lord.
appellant. This appeal is directed against, no, present appeal is directed against the judgment and decree, huh?
My lord.
Appellate judgment and decree dated 01/08/2025, passed in title appeal number 05 of 2021 by the learned district judge UPA. What is the, it's against you, whereby,
Again, against me, my lord.
whereby, what is the issue?
Whereby, my
Where is the
lord,
operative person?
whereby, my lord, judgment of the trial court, my lord, was upheld, my lord.
Whereby the judgment of the learned civil judge,
My lord,
senior division,
my lord.
senior division in senior division UPA,
Civil judge, UPA, my lord.
senior civil judge, senior division UPA
UPA,
is upheld.
my lord.
Issue, that's all.
My lord.
Upheld,
Upheld, my lord. Entitled suit number 7 of 2014, my lord.
entitled to suit number 7 of 2014. In that suit, what was the judgment decree
That judgment goes against me, my lord.
saying what? It is in respect of what? Land.
And, yes, in respect of the, saying a suit was not maintainable, my lord. My suit was not
Holding the suit not maintainable, filed by the appellant.
appellant,
Issue notice returnable by 4 weeks.
my lord.
The, why state party?
My lord, the land is government land, my lord. That's why the state, my lord.
Yes.
And private respondent is there, my lord.
Who is for the state? Have you served the copy?
Yes, my lord, I have served, my lord. That's why that is reflecting also, my lord.
In the cause list, my lord.
Who is the
Government,
government lawyer? Take steps. Then counsel for the appellant to take steps for service of notice of respondents.
respondent, my lord, or private respondent, my lord, or government, already I have served, my lord. Private respondent number, my lord.
Member, respondent number,
Respondent number, my lord. Yeah, but 6 and 7, my lord.
6 and 7, by registered for so and so, huh? List after 4 weeks.
My lord.
Huh?
And extra copy, my lord, I will serve to the government, my lord.
To learning council to, then, since although none appears for the petition, the state respondents despite service of notice, learning council for the petitioner to furnish extra copies to the learning council for the respondent number 1 to 5. 1 to 5. Okay.
High level.
Acha, yeah, but you write then that in item 12, huh? Heard Mr. What was the name of that? Jane or something like that. Yesterday, senior advocate, assisted by so and so, same, and Mr. What, something from Henry, huh? You find out, huh? Yes, next.
Item number 14.
My lord, it's a jail appeal, my lord. And there is a delay and it has not been filed in the proper format. So at this stage, my humble prayer would be, my lord, the record may be called for, and then later, my lord, the legal aid council may be appointed and let them direct to file an appropriate application, my lord.
Decision jail appeal. This appeal from jail is filed, assailing the what is this? Judgment.
Yes. Judgment and order.
Judgment dated 1609.
Yes, ma'am.
2024 was the special judge within bracket POXO, Teju, in POXO case number 20 bracket LDB bracket close 2021. Whereby the appellant has been convicted
10 years.
and sentenced to undergo 10 years of imprisonment with a fine of rupees 1,000 for the offence under section 376 AB public 511 of IPC, added with section 9 within bracket M bracket close public 10 of POXO Act. And 1 year for offence under section 506 dash Roman Captain 1 of IPC. That's all.
Yes, ma'am.
No default stipulation. No default stipulation.
No, my lord.
Call for the case there, the trial court records, right?
Yes, my lord.
This after
It's after, my lord, 4 weeks, my lord.
4 weeks.
My lord, that may be recorded that there is a delay so that later on, your lordship, we can place it before the
Delay of what? How many
delay of,
days?
my lord, 335 days, my lord.
It is noticed that there is a delay of 335
35 days.
days in preparing the appeal. Listed. That's
Yes.
all.
Yes, Your Honor.
Mr. T at additional appears for this.
Yes, ma'am.
Same.
Same, my lord. The
15.
conviction is different, my lord, and delay is 87 days, my lord.
You find out. Can you? Should I dictate or no? Okay. Then same.
Okay.
Find out. Don't make a mistake, huh? Otherwise, I'll dictate you. 17, 18, 19. All same.
Also, only
There is a conviction, right? Case number, name of the party and all, everything will be different. But same order.
Same.
Delay, you find out, where is the delay? You just, in 15, delay is
15, my lord, delay is 87 days, my lord.
87 days, then 16,
We find out they will.
final is provided. Huh?
Yes.
Hmm.
Obliged.
19, up to 19,
Yes, my lord.
20, up to
20,
20.
up to 20, my lord.
Item number 21.
No, we have called for the, as he suggested, trial court record and we'll appoint them and then
After-
we'll ask them to file a
Yes, yes,
condemnation petition.
yes.
Right.
Item number 21.
What is this? Why this
Please, your
has
lordship.
been listed for orders, admission.
Yes, Lordship. Lordship, there has been delay and not from the direction was given by this honorable court that after the examination of the victim in the special, before the special judge, the matter will be taken up.
Where it is?
Yes, Lordship.
Why this has been listed for admission?
Lordship, there is already the matter was listed for which
This matter after examination of the victim as per the order dated 20. There has been,
yes, Lordship, that is the ground, Lordship. I have-
victim has been examined.
164 is there, Lordship.
The victim has been examined or not?
Not yet, Lordship.
Then
No, the matter was, Lordship, adjourned for 5 times, Lordship.
it doesn't make a difference. There is a order, this matter after examination of victim as per the order dated so and so. Until the
Lordship, my prayer is that, Lordship, I want to,
Yet to examine, the prisoner shall be considered after going through the evidence of the, therefore the petitioner shall file a certified copy of the evidence of the victim girl and after that this bail appeal shall be listed for admission hearing.
yes, Lordship.
Have you filed that?
Yes, we have filed the orders, but there is no, Lordship, we have not prayed for the adjournment or any kind of next
You
day.
may know, court has directed it should be listed after examination of the victim. Right?
Yes, Lordship.
Therefore it has to be listed. It has not been examined.
Yes, Lordship.
Why?
Lordship, I want to read one citation.
It's-
This is recent.
Forget about, you have to file for, there's a wrongly or rightly, there's a order of this court.
Yes, Lordship.
Yes, madam. Why the victim has not been examined?
Lordship, the order is annexed there in the additional affidavit. The order copy which was given by the session.
Has she been examined?
No, your lordship, on
That is I'm asking. What order you have annexed?
The adjournment order. Which
Adjournment, why not concern? That's why I'm asking, questioning the learned PP.
yes, your lord, they,
Why this has been not examined?
your lordship, they have filed an additional application, your lordship, bringing into court's record the statement of the victim, your lordship. The statement of the victim has been recorded on 2 occasions. That
Hmm.
is on 8th of January 2025 as well as on 5th of March 2025, your lord.
Where it is?
Your lordship will find at page, there is an additional application, your lordship, affidavit.
Page number 46, Lordship.
43 is the first examination, your lordship.
40
43 is the first examination, your lordship,
by the court?
by the court.
Yes.
Uh,
This is on which date?
This is on 8th of January 2025, your lordship.
8th of January.
Yes, and the
Then
next,
why the order was passed on 21/7/2025? Saying that the trial court is yet to examine the victim by this court? This is 183
Yes, sir.
by the judicial magistrate.
deeply approaches, yes, your lord.
Huh?
Yes, your lordship. Why, it's a 183.
What he's saying is that except for 183, no examination has been done. Has examination means what? By the court only?
By the court only, yes.
Trial court? Why not? for so many months.
The last order is of 21st of October, when the PO was on leave, Your Lordship.
PO,
Yes.
who is PO?
Presiding officer was on leave, Your Lordship.
So you take instruction list next week, get it examined and we'll hear the matter.
Yes, Lord.
So wrongly, rightly, there is an order of this court that the matter will be taken up after the examination of the victim.
Yes, Lordship.
So admittedly, no examination has been done as yet.
Yes, Lordship. But 5 times it was called upon. And we are not allowed to even cross-examine. Once, Lordship,
Cross-examine, and before it is examined, chief, how can you cross-examine?
no, Lordship, on 15 it was examined, but the Honorable Special
Not
Judge,
Mr. So-and-so. That has not unnecessary waste time.
yes, Lordship, otherwise one direction may be given to the court for the recording of an examination of the alleged victim. Lordship.
Can we, in a bail application,
At least,
you take impressed upon the trial court.
yes, I'll,
Now, Lordship, we have submitted before the session judge that
Heard Mr. So-and-so.
my prayer, one last prayer. Just bear with me, with one prayer only. We have submitted before the district and session judge that matter is pending before the Honorable High Court. So therefore, the instruction was given to record and examine the alleged victim. But then the Honorable PO has stated that I have not received any direction. So matter was again, and I have annexed the order also. There is no ground why the matter is keep on adjourning. That's what I pray. Therefore, I pray for a proper direction may be given to the,
We just don't do give direction like that.
at least Lordship, a direction that
Heard Mr. So-and-so,
I
and
think-
counsel for the petition. Item 21, huh? Although this matter is to be listed after examination of the victim as per the order dated 21/07/2025 and 28/07/2027. 25, sorry. 28/07/2025. Comma, it is stated at the above that victim is yet to be examined. In view of the above, and considering the bail petition cannot be kept pending for want of examination of the victim, comma, it is observed that the learned public prosecutor to impress upon the trial court to do the needful,
yes, Your Lordship, I'll,
may impress upon.
yes.
I said, why not, like, we cannot pass, cannot just directly pass to examine and all that. But then at the same time, should not be kept pending for want of examination.
yes, Lordship, there is recently
Let's the matter after a week.
obliged.
What recently?
Recently, there is citation. The Honorable Supreme Court has stated that bail application should not be pending for more than 2 months. There is, if this court will allow, I will read it.
We're over conscious.
Obliged, sir.
Item number 23.
One of this RD matter, Mr. Picha used to appear. I've been requested to appear on his behalf. So if I don't have the brief also, my lord.
Yes. So
So some more
I
time.
know the matter is wrongly listed in admission. Matter, it should be listed in orders. Statements are not completed.
no, no affidavit has been filed.
My lord, no affidavit.
So next we'll list it for orders.
My lord,
Heard MS M. Karbak. Soki.
Yes.
Why you are not adding it? M. Karbak Soki. Learned counsel for the petitioner. Next para. Mr. Anderson, learned addition PP. Submits that. Additional Advocate General submits that. The Standing Council Mr. B. Picha is indisposed today. Therefore, press for listing of the matter after 3 weeks for orders as the response are yet to be filed. Where
Extra copies,
list accordingly after 3 weeks.
my lord, extra.
Matter number 24.
My lord, yes, there is item, part third item.
Yes,
My lord, I'll just briefly submit, my lord.
but briefly, I've heard you yesterday.
Yes, my lord, only I'll just summarize my argument, my lord. Private respondent has quoted less than the petitioner, my lord.
That I've noted,
Petitioner has
three
works in
works
hand.
at hand.
At
That
hand.
we have noted.
Yes, my lord.
Then
Uh,
only issue is whether the contractor, as per the NIT, from a contractor who has registered other than the state of Arunachal Pradesh can register, has to register under the
Yes, ma'am.
PW, this
Yes.
Arunachal Pradesh registration
enlistment rules.
enlistment rules too.
My lord.
That's only, you just make on that.
Yes, my lord. On the third, my lord, the third one was inconsistency in the commercial bank and national bank, and the insolvency certificate was is
You are admitting
required.
it's not nationalized
Nation-
bank, so we according to us.
It is
probably
not
say
an
it is not,
essential. Essential condition.
essential condition.
Yes, my lord.
Can be,
Now the main
main is the
question.
registration, I
Yes,
mean
madam.
enlistment.
yes, my lord, enlistment, my lord. My lord, in the NIT itself, it provides that registered contractors. My lord, will kindly see the NIT once again, my lord.
You read it, I've read it. You
Yes,
have
ma'am.
read so many times
It's-
yesterday.
On, yes, my lord, I'm just only on that point.
386.
Yes, my lord. From eligible, the project director RD Upper Subansiri district on behalf of the governor of Arunachal Pradesh invites supply item rates, rate tender from eligible and registered contractors. Registered contractors from APPWD, CPWD, BRO, BRIEF, APWD. It says registered contractors, already registered, ma'am. Under the APPWD, CPWD, BRO, BRIEF, and APWD. And emphasis is on the on appropriate category of class 2, domicile within the assembly constituency. However, thereafter, it says that shall be governed by Arunachal Pradesh district-based entrepreneurs. My lord, of course, on one hand, the NIT says already registered contractors under so and so, so and so. On the other hand, when we interpret it that it shall be governed by the Arunachal Pradesh district-based entrepreneurship, then under this act, there is a requirement that a contractor should be registered under the enlistment rules, enlisted under the enlistment rules. Now, there is some inconsistencies in the rules and this NIT. That is what I'm fairly submitting. That the rule says that to participate in a tender, you have to be enlisted under the enlistment rules of 2008. Now, here the NIT itself has already invited registered contractors under the other organization and the APWD also. It also talks about APPWD, registered contractors under the APPWD. So, my lord, this is a legal point, very interesting legal point raised. Now, in the backdrop of this tender process, my lord, the private respondent's bid is lower. He's the L1. In any case, the petitioner will not be eligible to be awarded.
Eligible, not eligible, forget about that.
Yes,
We
my lord.
just want to clarify
Yes.
on this.
This,
Whether these eligible registered contractors from, say, Assam or the GRAF or BR or CPWD is required to enlisted themselves under the rules of 2008.
Yes, my lord. It is provided.
my lord,
It is
that
coming
is,
into that point, my lord.
my lord,
Uh,
I'm fairly saying, under the rules, under the APP, this
It is provided in the
district-based,
rule.
district-based entrepreneurship rules, they are required to be enlisted. But the NIT itself says that NIT itself has invited that those who have already been registered.
No, registration and the enlistment is not a it's the same. Registration
Yes,
and the enlistment is same.
Yes, same.
No,
same.
no, my lord.
Registration and
You can be a registered contractor in any works department, my lord. Whether it's in BR or whether it's in any work department in the state, my lord. But apart from that, my lord, you have to be enlisted in the Arunachal Pradesh contractor enlistment rules, my lord.
You know, how you can force the contractors who has been registered in other
Yes, but
organization?
it is provided in the rules, my lord.
Let us see the rules.
Yes, my
Only we have fixed it for rules only.
Yes,
That's
ma'am.
exactly, my lord.
See, there has a bearing. If we find
Yes,
that the contractor, respondent number 6 is not eligible to participate without registration, then you have to go for a fresh tender because he
Yes,
is not also eligible.
My lord.
He is not
No, my lord.
entitled. Yes, what does it say?
My lord,
Unnatural and enforcer,
Page
unlisted for
69 to 69.
no, page 1. 4, my lord. The rules, my lord.
Huh?
Clause 4, my lord. The
Huh.
next page, my lord.
Applicability.
Applicability, my lord. May I read it?
Deputy enlist contractor who intend to work with the department. Arunachal Pradesh, this is what?
Enlistment rules, my lord.
Huh?
Enlistment, contractor enlistment. rules.
Yes,
This is applicability. How it will be applicable, my lord? How it will be enlisted, my lord? Now, may I read it? Applicability. The AP, Arunachal Works Department, enlist contractors who.
AP means what?
Arunachal Pradesh, Work Department.
Works, okay. Enlist,
Contractors who intend to work with the department. It is done to have a ready list of suitable and competent contractors for APW work so as to minimize requirement of verification of credentials of contractor at the time of individual tender. At the same time, only those contractors are allowed to continue in the list that remains active in APWD and perform well. Now, my lord, the query has been answered here, my lord. Any Indian individual, sole proprietorship firm, partnership firm, public limited company or a private limited company or a cooperative society registered by the Register of Cooperative Society may apply for enlistment as a contractor in the APWD under these rules, provided the eligibility criteria and other conditions are fulfilled. The enlisted contractors have to abide by all the rules made herein and as amended from time to time while their enlistment is enforced or not declared as insolvent or nullified.
My lord, this is the enlistment rules of 2008. It says may. Anyone who wants to may enlist themselves. Whether it's a cooperative society, public limited company or not. It is for enlistment. They may, if they want to work.
so the Entrepreneurship Act rule says that it has to be registered to
No, madam.
participate in the tender process.
This is the enlistment rules, what my learned friend has shown.
Yeah.
It is the applicability of the enlistment rules, my lord. Enlistment rules. Now the rules, the 2000 district-based entrepreneurship rules, that says the contractors, entrepreneurs before participating in tenders must satisfy the following conditions. That in this, as per this, only the problem starts, my lord. The district-based entrepreneurship or professional must be duly registered under the Arunachal Pradesh contractor enlistment rules 2008. Here the problem, or not by the enlistment rules, it is because of the district-based.
No, I have understood.
It is the act itself.
Now, here,
The
the
rule
rule says something else.
Ah,
So, rules says something else, and the NIT says,
so what is your interpretation?
my lord,
We're ready to give a deference to your interpretation.
my lord.
Tell us the interpretation.
No, my humble submission will be, the department has asked, invited tenders from all these other organizations also, including the APPWT, my lord, also, who have already been enlisted, and the
Not
other,
enlistment.
my lord, the NIT says.
But NLT also says.
So we have
The
to,
enlistment and the registrations are two different things.
Two different things.
my lord, has to be, what it says has to be registered, my lord.
Ah.
Enlistment rules. Have, in the enlistment.
Entrepreneurship Act and rule says that it has to be enlisted.
Enlistment.
That means under this rule,
Yes, my lord.
2008 rule.
Yes.
Registration is something else.
Something else.
Ah.
Registration, my lord, registration and.
So there is so far as the applicability is concerned, any Indian individual, sole proprietorship, partnership firm, whatever, may apply for enlistment.
Yes,
There's no bar, or there's not, it's not bar that the other contractors who have registered in, other than in Arunachal Pradesh cannot enlist themselves. Because if the contractors registered outside Arunachal Pradesh can enlist, and the rules requires that for participation in the tender, a contractor has to register, or not registered, enlist under the 2008 rules, then
my lord, in fact, the word enlistment and registration has been used interchangeably, my lord.
I don't think so.
Because they also have a registration certificate. Contractor, what is called, sometimes called registration certificate. It is sometimes called the enlistment certificate.
No, my lord. I am a
You are an enlisted contractor or a registered contractor.
No, my lord. I
Class
am
one class two registered
class two
contractor.
registered, and then I have enlisted myself into the Arunachal Pradesh contractors enlistment rules, my lord.
Registered contractor where? That is the question, madam.
In the AP Works department. Now, my lord, in my humble submission, my lord, these rules, in fact, supports the private respondent, my lord. Since his firm is registered in the Assam Public Works Department, my lord, the requirement was that he has to, in order to work in Arunachal Pradesh, being a domicile from the Arunachal Pradesh, he has to enlist himself in the Arunachal Pradesh contractor enlistment rules, my lord. There is the requirement, my lord.
Yes.
What is the precedent, my lord?
My lord, I'll just sum up, my lord. I'm not, because to my understanding, the registration is given, the petitioner's own registration is under the enlistment rules of 2008. It is registration. And so, my lord, this enlistment and registration is being used interchangeably, my lord.
Okay.
In no other department, there will be a separate enlistment certificate or a registration certificate.
This page 58 is what?
My lord, page 50, no?
Ah. Please to enlist the following contractor in class two BNR under civil category.
Yes, my lord.
This is you.
Yes, my lord.
It is yours.
Yes, my lord.
It's enlisted.
Yes, my lord.
What is the registration?
No, this is the registration certificate,
Then
my lord.
That's why.
No, my lord. Okay. But if it is required, my lord, if enlistment is required, let them show their enlistment contractor, my lord, in Natural Works Department, my lord. They don't have that, my lord.
What they call this registration certificate, this is the enlistment certificate.
See, one thing, this Entrepreneurship Act is for the state of Arunachal Pradesh,
My lord, my lord.
right? Where is that Entrepreneurship Act page?
That is, in fact, the rules at page 68. It is not exactly the act, but it is the rules.
The contractor entrepreneurs before participating in the tendering must satisfy the. So according to you, once you are registered,
Yes, ma'am.
the not
But my lord,
not registered other than the in the state of Arunachal Pradesh, you don't have to enlist again under the rules.
My lord.
According to you, if the contractor registered, if outside the state or other organization, other than these rules, they need not be registered or enlisted under these rules.
No, my lord. I'm not saying that, my lord.
Yes, then
A contractor can be enlisted in another, in other departments or in other state. Likewise, he can be enlisted in the under the enlistment rules also. What I'm saying is that the NIT has invited all others also, apart from those who have already enlisted under the enlistment.
that
rules.
we have understood.
Yes,
Suppose a person is registered in Assam in this case.
yes.
Does he need to enlist under the rules of Arunachal, that is 2008 rules?
Yes, my lord. The rule says,
Then
no, my lord. Even if the rule says, what I'm saying, that if the NIT itself has already invited others, those who have already registered in elsewhere, and it has been made specific that these are also invited.
yes,
Yes, and the tender process shall be followed under the district-based entrepreneurship rules. What I mean to say that already the registered contractors elsewhere has been invited along with this,
in other
APPW.
words, only the requirement is for the contractors who have enlisted in Arunachal Pradesh.
No, my lord. The applicability of this district base is for another thing. It should be a domicile, because the district based entrepreneurship says not only the enlistment, it is for the domicile of that jurisdiction, assembly constituency, and also the category of the contractors. The requirement of this being enlisted has not been emphasized. As per the NIT, the requirement has been made open, but the others.
You read that last line,
Yes,
shall be governed by the Arunachal Pradesh
Exactly, my lord.
Entrepreneurship Act.
That's why there,
The
my
Entrepreneurship Act and rules says that a person has to compulsorily enlist under the 2008 rules
My-
for participation.
my lord, that's why
That's why simply I'm asking
there is an
whether according to you, the contractors who has already registered in Assam, for example, or the BRO, need to be enlisted again under the 2008 rules, according to you.
Yes, my lord.
In that case, 6 is not eligible.
No, my lord, they have to be, but the NIT, that's why I'm saying
NIT
the
calls
NIT
from
is-
the contractors registered under Assam, Arunachal, BRO, GRO, whatever, from a domicile.
Yeah.
Which shall be governed by the
exactly, my lord.
Entrepreneurship Act
The
and rules.
difficult-
The Entrepreneurship Act and rules provides that for participation, every entrepreneur or the contractor has to enlist under APW rules 2008.
My lord, that's why there's, we'll have to harmoniously interpret what was the intent of the NIT inviting others. Why was it mentioned that the registered contractors of APPWD, which is already enlisted,
Hmm.
and BRO, GRIF, and APWD, which are not enlisted? The emphasis was on the,
APWD.
my lord, no.
Contractors
emphasis,
from
no,
Arunachal. Simple
the
language,
domicile,
contracts from Arunachal.
yes,
Contractors from Arunachal.
yes. Emphasis was the domicile of.
Who has not registered outside or the state or the other organization?
Yes, my lord.
That is according to.
The emphasis was on the domicile of that district or of that jurisdiction assembly constituency and the category.
I don't find it's a very interesting legal point.
My lord,
It's matter of interpretation only.
yes, my lord. Now, my lord, if we directly go to the second part of
On the
the,
face of it appears to be with violation of the rules only.
yes, my
You
lord,
cannot issue an NIT if we accept your submission.
Exact-
You cannot issue an NIT which is against the rules and the act.
exactly, my lord. That's why I was submitting that the NIT was not challenged. He participated. When the private respondent was technically found responsive, he did not object. He did
Well,
not
that
object to
meant-
the
that meant-
responsiveness of the,
The one has to stand on. in
Yes,
his
my
own
lord.
leg, on his own merit of the merit, not taking the weakness of the other.
Yes.
Defendant, something like that. Judgment is, you remember? Not right now. Find out that judgment.
yes, yes.
Help us.
Yeah. Now,
Exactly,
now-
I forgot that exact. This language.
ultimately, if we go by the strict interpretation of the rules, all the contractors who have to participate in the tenders shall have to be enlisted, my lord.
So?
According to, but therefore, if we interpret it in that simple sense, the meaning and the invitation of other registered contractors from other departments or the other bodies will be fruitless, and would not there would not have been any occasion to invite them. It was because the emphasis was on the,
So you are admitting that there's a inconsistency.
yes,
In the rules and the NIT is
NIT
not,
and the,
not in conformity with the rules
yes,
or the act,
Yes.
provision of the act.
yes, there is
Therefore,
inconsistency.
what is the way out?
Now, my lord,
How
No,
you have
this
harmonized
is,
it?
that's why I was saying
When
that
there is
it's a very,
Clear inconsistency between your NIT and the rules and act. What's the question of harmonizing it? You cannot.
yes, my lord. Now, the question is now, he has not challenged it. There was, everyone participated.
That is too technical.
Now it is,
That is too technical.
yes.
Not
So, my lord, what now in any event, he is not eligible to participate or to be awarded the work.
that is something different.
Whether,
That we have heard, we have already taken, accepted that.
yes, my lord.
All were, he has also accepted.
What my,
But only issue is this.
yes, my lord. There
Which
is
I am
an
not getting-
inconsistency.
Yeah,
Yes.
which I am not convinced.
Yes, my lord. I also
You say if it is consistent, there's a clear inconsistency.
clear
The question of
inconsistency.
harmonizing it.
No, my lord.
The rule and
yes.
act will prevail. And if you have not done as per the rules, requirement of the rules and act, goes.
My lord, there is a clear inconsistency, but what I'm saying, but that they have not challenged that and they have participated. Now, what is the public interest now?
I am not interested in technical things. I just wanted to know what is the way out.
Because
It has
now,
to be resolved.
Way out is, my lord, inviting for a first tender, man.
because now,
That is what the rule
But the
provides.
problem is, even if we go ask for a press tender, you are still not eligible.
But then, my lord, that is what the rule says, my lord. My lord,
If you are not eligible on your instances, why will ask direct for?
My lord,
What precedence will cause?
but my lord is,
It's a public interest.
but my lord is, well aware, my lord.
You make
No,
up your case that you will be eligible. Then we'll direct them for first tender.
My lord, then, I need to seek instruction, my lord, whether the work that, say, if it is a first tender, my lord, they say at that point of time, I had 3 contract. Now, it might be, I mean, I don't have any instruction upon that, my lord. That might have been completed, my lord. So I might be eligible at that point of time, my lord. That might happen, my lord. But my lord is well aware, and it is a certain
like you are-
position of law, my lord,
Like,
that when an institute says something to
when
be
you are
done in a
saying
certain.
you are not eligible now also,
My
still you are not eligible. It's like you want to just take them to that.
No, no, my lord, no, my lord, that's not.
मैं तो डूब गया लेकिन तुझे भी लेके चल.
नहीं.
That's the kind of
But
approach you are
it's a subtle position of law, my lord. When the statute provides for doing certain things in a certain way, it has to be done in that manner, my lord. Now, the statute provides, like, there is a guideline, there is an act. I'll just. It has to be done in that Yeah, manner. my lord, just,
You complete your-
yes, my lord. So that's why I was submitting, there is an inconsistency, and it's a very interesting legal point they have
And
raised.
recording, huh?
Yes, my lord.
There is a inconsistency.
In the rules, the bid documents and the NIT. Vis-a-vis the NIT.
Yes. Then
My lord, this, an interesting legal point has been risen, my lord.
I don't find it legally.
My lord, my submission only, no. It's a interesting legal point.
If we find that it is not in consonant
My lord,
rules,
only my submission, my
proceed.
my lord. Yes. My lord, since we have the same, I mean, in Adi, there is a very a court dialogue, which says like after speaking,
Anecdote.
no anecdote, after speaking your, I mean, after speaking you cannot lick it back. So he is the department or the additional AG. The government has enacted this law. They have invited a tender. Now he says that discrepancy, it is that, there is, I mean, he cannot lick his own. He's put on the speaking area. No, my submission only that it's a legal point, interesting legal point. Yes,
You just address on this. If it
Yes,
is
my
an
lord.
interesting
Now-
legal point, please address
my lord.
for our consideration. We'll
my
consider
my
it, sir.
my submission will be that NIT has specifically invited other bidders also, apart from the already enlisted contractors.
Yes.
If we strictly interpret that the other bidders should also be
Enlisted.
should also have to be enlisted, then the NIT, the meaning of the NIT inviting others will become known as this useless, my lord.
Yes.
We have to give a meaning to why the invitation was done for other bidders.
Who has forced you to give that last sentence? Shall be governed by
That
the
that is there. That is there.
entrepreneurs
That
act
is there. my
and
lord.
rules.
But that's why my humble submission was that the
and the
emphasis.
requirement is you have to enlist.
Yes, my humble submission was that the emphasis was on the local contractor of that jurisdiction assembly constituency in the category of the contractor he is registered under class 2.
So
That
you want
emphasis
that-
was on that. Emphasis was
the-
not on
Ah.
the, because again to be enlisted.
Hmm.
Emphasis was not that. It was already registered. It was no, the emphasis was not for again re-enlistment or re-registration under the enlistment rules of 2001.
Therefore, in other words, if I correctly understood, so far as the contractors registered in other states like Assam and other organization, BRO and GREF, it has to be written down. The provision of act has to be written down.
Yes, Madam. But I would say that emphasis was on that, on the local contractor,
Although there
although
is a-
registered elsewhere.
Although he has raised a very interesting legal issue,
Yes, Madam.
which I find
Otherwise,
There's
if
no legal issue.
otherwise the invitation of others in the NIT, it itself will be rendered meaningless, my lord. We have to harmonize it. What was the intention of the department, my lord? It's although that the rule says internally, the rule says otherwise, but emphasis. That's why my
otherwise normally one has to participate in
Yes.
tender, one has to enlist.
enlist
under the rule.
under the rules.
That is the point.
Yes.
That is the problem which I am finding.
Yes, my lord.
difficult.
There-
That is the difficulty I am finding. When you say number one, inconsistency. Inconsistency means it cannot be reconciled, is not it? Cannot be harmonized when there is inconsistency. Number two, when you say that it has to be as per the rules, it has to be enlisted, one has to be enlisted under the act and the rules. And when you say clearly that it shall be governed by the act and rule, entrepreneurship act and rules, it will be governed by that only.
Yes,
If
my lord.
one does not, if a contractor does not enlist themselves
Yes, my lord.
or is
In
not
fact-
enlisted itself in the, under the rules, so he is not eligible.
In fact, the
As per your NIT,
yes, my lord. In fact, the interpretation of the department was that only emphasizing on the local. Now, this is the interpretation what the department has. We have given it in our affidavit that we were more to the emphasizing on the local contractors, the domicile Domicile
your
and the
emphasis on domicile,
and category that
forgetting the other provisions.
because my lord knows that the other provisions of this they might have skipped this that while issuing the notice although if you invite others, but the rules you will again have to, but that is an interpretation. What was the intention of the department is simple, that
You have given in your
affidavit.
your intention.
Yes, that it is for equitable distribution and for it is.
So it
There are many contractors.
exactly, it's not an hidden criteria, but that
It was not a hidden criteria.
hidden-
It was
hidden-
for invitation for all.
how the participants and the bidders would know your intention. It has to be spelled out in the NIT.
My lord, the NIT, that's why that NIT, it was
Otherwise,
clearly
that will
given
be
that
chaos. That will
registered
be-
contractor elsewhere are also invited.
It
but-
will be too arbitrary when you have your intention not spelling out,
No, my lord,
particularly specifically spelling out in the NIT. What do you mean by NIT?
NIT has
The meaning
clearly
of
said,
NIT, you have
My
to
lord,
give clear.
yes, clearly said that these, even BRO,
you have to
REEF and
specify.
others are also eligible. That is what the intention was. The
Okay,
NIT was clearly intended that everyone is open.
okay, thank you, sir.
So, my lord, what I'll just sum up, my lord. It's a Manrega supply work, and in a year it is for 100 days only. Now,
Or 4 months.
for 4 months remaining, but I have
Will direct you to issue a fresh tender within a month.
but in a month,
Within a month.
there is a ceiling limit of only 15 working days. So already now only 60 working days is remaining, my lord. It cannot exceed 15 in a month. So already because of the pendency, now the public interest, if he is not
I'll
going to suffice,
consider.
if he is not going to get anything, just for in the furtherance of public interest only, my lord will take a decision, just not making out a legal point.
You know, madam, 5
That's all,
minutes.
ma'am.
I heard him because he's the author of the tender. He's the employer, he's the boss, he's everybody, everything. That's why I heard him.
Lordship, I will also not repeat any submission.
Yes.
Lordship, may just supplementing what he said,
Yes,
page 65 is the act itself.
yes.
If we read the first portion of the act, where the intent of the act is made clear,
Preamble.
yeah, preamble, I was missing that word, to provide an incentive to ensure greater
Not
participation.
preamble, in fact, it's an object.
Yes, object,
What do we call it?
intent of the act, basically. The reason why this act was passed, to ensure greater participation by district-based entrepreneurs and professionals as a part of government policy, thereby facilitating decentralization of development activities with greater participation.
Yes.
With greater participation of people from nook and corners of the state of Arunachal Pradesh to build a society of people with uniform social and economic status in the state and matters connected therewith and incidental thereto.
Hmm.
So the key word here is greater participation from all nook and corners,
Hmm.
Lordship.
Yes.
Now, in fact, in my humble submission, the NIT which has been floated
Hmm.
is more in consonance with the act than the rule itself.
Hmm.
The rule which has been passed, which has been enacted, sorry, the rule which is connected to this act, the rules which were harping since yesterday, there is a restrictive, instead of a greater participation, it restricts other people who are domiciled within the districts for whom this rule is, the act itself is intended for. In fact, it is restricting them from participating if they are not enlisted, Lordship. So in my humble submission, the NIT is more in consonance of the act. So if it is to be interpreted, this aspect may also be taken into consideration. Also, Lordship, as per the enlistment rules, Lordship, there was a confusion whether this is enlistment or registration or something. But if we see the enlistment rules, this enlistment rules of 2008 is an extension of the registration which was earlier done in the Arunachal Pradesh Public Works Department. So that is why it is given in the rule itself that they will, those who have been already enlisted earlier in the old PWD, their enlistment will be extended. And in the format which is given in the rules itself, there is also a questionnaire whether a person has, whether the applicant is already enlisted in APPWD, that is the old APPWD, or any other department. So that means any person who has been in the enlisted or registered in a department of the government of Arunachal Pradesh are the persons who may be enlisted. These are not people who are registered elsewhere, Lordship. So in my humble submission, that is there, man. Another thing is, Lordship, I'd like to point out that
Are you not saying that you being the registered contractor of the Assam
yes,
PWD
yes,
and the domicile of the particular area
yes,
or Arunachal
yes.
in a particular area is not required to enlist under this 2008 rules?
Not necessarily not required, not, it is
Otherwise,
actually,
you may.
I may, it is not clear actually. It is not clear, but what I'm saying is, since this is an extension of that old APWD, now all the departments are included. Earlier, it was only PWD. So therefore, there was registration under PWD. That is known as APPWD. These are, if one is already registered there in the old APPWD, then they are automatically enlisted here as per this. And that is why there is a questionnaire whether you are enlisted under APPWD or other department. Other department meaning the department, other works department. So it is not the enlistment and the registration, unlike what my learned friend has said, is one and the same thing. It is used interchangeably. But of course, if somebody has to get himself want to work in the department or the collectively known as Arunachal Pradesh Works Department, which includes all the other engineering departments, also the RD, then one can register, can enlist. What I'm saying is that the NIT itself, at the cost of repetition, the NIT itself is actually more in consonance with the object that is sought to be achieved than the rules. The rules, in fact, give a very restrictive meaning, meaning thereby any person who is not enlisted here cannot work, even if domiciled from that district. The act itself is to give a wider net, but here they are using tadpole nets.
We cannot help it out.
Lordship, and another thing which
Is on the statute.
yes, that Lordship, since I am not the author, I cannot. I'm only guessing what they are saying, why they have done this, Lordship. Now, Lordship, in this particular 386, this is regarding Payeng Circle. There are 5,486 households under Manrega. And I have already supplied the materials. on 30/6/2025, before the writ petition was filed. It is there in the godown, but because of this interim order, it is
All
the
all
work.
the materials,
Yes,
all the materials.
yes, Lordship. So now, Lordship, because of this interpretation, because it's not my fault. If they've called for an NIT, if they've called for APWD also, I have bona fidely, I have participated and I have now, Lordship, a person who is not even eligible, who has made a false affidavit at his behest, who cannot even stand on his own legs, comes to this court. Where is the public interest in Lordship allowing this writ petition? That, Lordship, is my humble submission. Obliged.
Heard Mr. Opada, the counsel for the petitioner. Separate orders, huh? Same order, but separate orders. 12 and 13, huh? Also heard Mr. N. Ratan London, Additional Advocate General, for respondent number, state respondents number 1 to 5. 1 to 5. And MS N. Dagel, counsel for respondent number 6. TAB or what? I'll pass the order. Well, see, 6 has already supplied he has executed the work
Therefore, my lord, yesterday
just before the writ petition was filed. And you are not eligible. You are not eligible. I mean, you are eligible, but you cannot succeed. You cannot be given. And even if there is a fresh tender, still you are not
I might be eligible, my lord. I don't know.
eligible.
My lord, I think the division bench has already,
We'll see, I'll
it
consider.
it has already decided upon that matter, my lord.
But I will see.
Whether eligible or not, and whether she is eligible or not. That matter has been already
see.
already
We'll see.
decided, my lord.
Okay. Dispose of.
Obliged.
Item number 26.
Please, Your Lordship.
Yes.
Your Lordship, this is a regular bail application, Your Lordship.
Yes.
Under sections 6 of POCSO Act, Your Lordship.
Hmm.
Here in this case, Your Lordship, the accused person was arrested on 6 September 2024, Your Lordship, and has been in custody for more than a year, Your Lordship. And in this case, Your Lordship, the police has already completed the investigation and has filed a charge sheet, Your Lordship. So, Your Lordship, on 28 November 2025, 2024, Your Lordship, CC has already completed, Your Lordship. And therefore, Your Lordship, on several occasions, the Honorable Session Court had issued notice to the victim and the complainant for examination as PWS, Your Lordship. But despite of receipt of the copy, they remain absent in the court, Your Lordship. In this, as a result, Your Lordship, the Honorable Session Court issue a non-bailable warrant of arrest, Your Lordship.
Against the victim.
Yeah,
Against the victim.
victim and complainant, Your Lordship.
Complainant.
Yes.
Non-bailable warrant of arrest.
No, your bailable warrant of arrest. Already examined.
And
And on 24th.
how many witnesses?
But as per the charge sheet, it's showing 15 witnesses, out of which 2 has been examined, my lord.
Only 2.
Yes,
Only 2, Your Lordship.
When the charge sheet was filed, when the comments, trial comments,
the charge sheet was filed on.
record say there. Record say there. Give it to me.
3/11/24.
You find out from here. Flagged it. 15 witnesses,
15 witnesses.
prosecution witnesses.
Yes, as per the charge sheet, my lord.
To examine only
Two.
two.
Yes.
And the complainant and victim only.
Started when? Which?
On
When
20
it commenced?
Because we don't have the, my lord, the updated TCR report also, my lord. I've just communicated from the concerned public prosecutor there who is conducting the case.
So,
So not record, but in record, it has not been updated, my lord.
how do you know? How do you know? It's been more than a year.
Yes,
What is to be done?
My lord, if there is a delay, then your lordship, this court can direct or expedite the trial, my lord. That can be done. It's a POXO matter, my lord. And your lordship, we all are well aware of the X versus Rajasthan matter, my lord. And your lordship, the statement, my lord, may kindly peruse the statement also, the victim statement. My lord. It clearly is,
Only two witnesses out of 7.
yes,
I mean 15.
my lord.
yes.
Is it been taken up every month or every, after
Ev-
how many days?
Every month,
It's been regularly taken up.
yes.
Then it's on in its page. You wait for some time. May not be ground for.
Your lordship, the victim has identified the accused person during the cross-examination. But your lordship, as per Article 21 of Constitution of India, every person has a right to life, and personal liberty, your lordship. Whereas your lordship, the bail is the rule and jail is an exception, your lordship, especially when the investigation is completed. And there is no further need for custodial interrogation, your lordship. And moreover, your lordship, as per the section 35, subsection 2 of the POXO Act, it says that, your lordship, the trial has to be completed within 1 year, your lordship. In my case, your lordship, even after more than one year of custody, your lordship, the trial is still incompleted, your lordship. And therefore, the further detention of the accused person is against the spirit of the POXO itself, your lordship, which mandates the speedy trial, your lordship. That is my humble submission, your lordship. So in this regard, your lordship, we are ready to avoid any strict condition, your lordship. We are also ready to regularly present before the police station regularly, and we are not even leave the jurisdiction of the court. Your lordship.
What is the statement?
My lord, CTC, we have furnished, my lord, CTC of the victim statement, victim and complainant. PW2, my lord, is the victim, my lord.
This is the first time.
Yes.
This is second time or what? Bail application.
Okay, second time, your lordship. First, earlier it was rejected by the Honorable Session Judge.
Before this court, it's the first.
Yeah, it's a fresh one.
Very difficult.
Your lordship, the accused is a scrap collector, your lordship, who earns daily
POXO Act.
wages
POXO Act.
to feed his family, your lordship. Keeping him in the custody, your lordship, it will cause
POXO Act.
irreparable hardship to the dependents, your lordship. Moreover, your lordship, the delay caused by the prosecution side only, your lordship. I have been in the custody for more than 1 year, your, without any misconduct, your lordship.
How many days? Exact date you just tell us.
417 days, your lordship.
417.
Yes, your lord.
When the cognizance was taken, when the cognizance was taken,
Yes, my lord, I'm going to. the
When it
record.
was taken? Heard, mister? You find out?
Yes, my lord. I will, flag mark the, my lord, the appropriate,
Ah. Heard, mister?
order.
Tigame, Your Lord.
Tigame, learned counsel for the petitioner. And also heard Mr. T at the learned additional PP. And Miss MS J Doji, Jaya Doji, learned legal aid counsel for respondent. Respondent number 2. This is an application under section 483 of BNS 2023. Praying for grant of bail to the accused, namely Nurul Ali,
Nurul Ali, actual lords.
in connection with the POCSO. What is this case number?
POCSO case number 16 of 24, my lord, in ITA PS number, WPS case number
WPS.
45 of 24.
POCSO, you have not given the case number. POCSO case number, where is this?
It's in the order sheet, my lord.
POCSO case number 16 of 2024.
Yeah.
In ITA WPS,
WPS.
WPS case number
45 of 24.
45 of 2024. On the section 65 within bracket 2 to
BNS
135, 137 within bracket 2, bracket close 351 of BNS 2023. Read with section 4 of POCSO Act 2012. Who has been arrested on when?
6 September
6/09/2024.
24.
The case set up by the prosecution is that on 03/09/2024, a written FIR was received from one Srimati Nabiran Bibi. On the Darling under Papu Hills Police Station. That to the effect that on 03/09/2024 morning, when a minor daughter mixed X in bracket name with a love, as it about 10 years, complained about having acute pain in her private part. She was rushed to Trims Hospital, Naharlagun, and during her treatment, the her treatment, she disclosed that the daughter disclosed that she was sexually assaulted by one unknown person on 01/09/2024 at quarry line of Borum village. She further revealed that He said Alice Wilson had given her 20 requests and they were,
Complainant, my
the complainant was not cooperating, was not attending for, examination, ready for that available warrant has to be issued.
Yes, it's already been
According to you.
recorded. They have all, their statement has already been
Now,
recorded.
by now it has been recorded.
Yes, my lord.
Let me see,
Yes, my lord.
cannot say. Maybe rejected or maybe allowed. I'll see.
Much obliged.
Obliged, yeah.
We'll continue, huh? We'll pass the December, we'll continue.
Okay.
Item number 27.
Hmm.
May I please, Your Lordship?
Yes,
Lordship, this morning we have filed additional affidavits so as to bring the malad on record. That malad has been, as per the direction of this noble court, we appeared before the malad IO of the case on 24th. Accordingly, malad bail, we furnished the bail bond, local COT as well, malad. Later on arrested, and later on released on bail, malad. So in additional affidavit, malad, and also recorded our statement, malad. And that way, malad, we are cooperating with the IO of the case, malad, investigation.
what? Hmm? Disclaim. Okay. Hmm. What is the offense? Okay. For one more.
Okay, we'll file FIR copy
Hmm.
at page number, my lord, 23 of my bail application. This was lodged by one Anil Hussain, who was the center superintendent, my lord,
Hmm.
page number 23. Even I am not named a buyer. My only allegation is some
On the basis of the statement of the accused, co-accused. Hmm. Yes, Daddy. See, larger the conspiracy is, there must be some larger conspiracy. Leakage of paper.
Malad, in that case, Malad, may I make fair submission, Malad? Malad, I may be allowed to go on bail, Malad. If Malad, this accused person is not Malad, cooperating, Malad, the liberty may be given to the IO of the case to cancel the bail, Malad.
Where are you?
Malad, I am now in my home statement after this
Where?
at Haryana, Malad.
Very difficult.
Malad, in my paragraph, Malad, categorically, I made statements that if Malad, the IO allowed me to go on bail, Malad, saying that you will be issued summon, Malad. Let them issue summon, Malad. I am ready to cooperate, Malad. In the event, Malad, if I am failed to cooperate with the IO
No,
of the
that
case,
was because of the interim bail.
Malad. So therefore, Malad, I may be Malad, allowed to remain on bail, Malad. If Malad, the accused person is not cooperating, Malad, there always liberty is with Malad, the IO of the case to cancel the bail, Malad. Malad, the approach before reasonable for cancellation, Malad. That liberty may be Malad given. Unless if
No,
I am failed
these,
to cooperate,
that's type of offense. Easily, I mean,
through, Malad.
very
That-
difficult.
And there is an involvement of their
There are huge numbers of accused are involved. 47. How many you have arrested? 10 of them. He's 11. No, he's 11 accused. There are other 30, more than 30,
Malad, most of them,
27,
most of them have already
37.
been released on bail, Malad. All accused persons have been allowed to go on bail, Malad. One of the accused person is also enclosed, Malad. in
Where
the
is his statement?
because we have to by denying these two.
No, Malad, that is not correct.
Here in the,
Malad, paragraph 1.
is not proper.
In my additional affidavit, Malad, I have clearly stated that I was allowed to go on bail with a verbal directions to the to appear before the IO of the case as it been called for, Malad, for recording of the statement.
Will also be intimated him for recording of his statement.
Correct.
You have not been, your statement has not been recorded.
Malad,
Where it is where you have indicated?
Second,
You are the kingpin.
they resign me as kingpin, Malad. That is allegation, Malad. I'm not the only one, Malad, who Malad alleged to be involved, Malad. And most of rest of the Malad alleged accused
That's
persons.
the problem. There's so many people.
Yes, Malad. And most of them have already been allowed to go on bail, Malad.
our town to record also, there are so many factors in the territory, in the department.
Let us do one thing. You provide your mobile numbers, mobiles,
My lord,
handsets
yes, ma'am. My lord,
by Friday.
I'm ready to cooperate with the
By
IOB.
Friday, we'll list the matter next week.
Yes, my lord.
Interim order will continue.
My lord.
All right. Next, we heard Mr. You appear for interrogation by providing the handset, mobile handset and other details
Other details, madam.
on Friday.
Madam.
This Friday, we'll list the matter on Tuesday.
Yes, ma'am.
All right. Heard Mr. M. Katalan counsel for the accused applicant, and also heard Mr. Deloy Leonard PP for the state. Next para. Who has produced the case diary with its status. Next para. Upon perusal of the case diary and the status of the investigation, it appears that the petitioner, the accused applicant has been named by other co-accused being the main facilitator. Then there appears to be larger conspiracy involving the larger conspiracy in the case. It also reveals that the accused applicants has failed to produce the two mobile handsets which should be required for proper investigation on the ground that either he has on the ground that he has lost both the handsets. How you can lost it? It's very difficult. Considering above, the accused applicant is directed to appear before the investigating officer. No, before that you just said, the statement of the accused applicant has not, could not be recorded. As he has failed to provide his details, including the phone numbers and email address. In view of the above, it is directed that the accused applicant shall appear before the investigating authority officer on Friday 31st, 31/10/2025, and to further and to furnish his details and to produce the 2 handsets. For further interrogation. For interrogation and recording of the statements. The interim order passed and this will continue. List the matter. No, this is the original. That you produce on the next day.
The matter will be listed on third month.
Learning PP. No, the original CD we sent back. Learning PP to produce the status and the CD, scan copy of the CD on the next day.
Fourth month.
List on 4th, 04/11/2025. Difficult.
Malad, in other case, Malad, we have the statement have been recorded.
Same order, same. This is the same status by the IR.
Yes.
Same in other case also.
Yes.
Matter number 29.
Same order, right?
Yes, sir.
Charles Sobraj.
Service is awaited.
Yes. Award service report. Mr. Deepak is present, for the petition is present. Award service report. List after 3 weeks. Interim order process, yes, will continue.
Matter number 30.
Yes. What is to be done? It's everything is, paperwork is ready. And Mr. J. G. Nilan, counsel for
Petitioners there.
year 4. Non-appeals for the appellant. Ms. P.L. Hage, additional PP, and Mr. J. G. Nilan, counsel for respondent are present. List for hearing. And paper book, no, list for hearing after the usual course.
Matter number 31.
May I please, Your Lordship?
Yes.
My lord, this is for quashing on compromise. The petitioners are,
List for admission hearing. List for orders today.
yes, Lordship.
Scan copy is received.
Yes,
Third MS. And then counsel for the petitioners. And Mr. Deloy, Leonard PP for the state. Scan copy of trial court record is received. List for admission hearing. after a week.
Item number 33.
Hmm.
Lordship,
You have not taken steps. Yes.
Lordship, service was,
No, no, you
steps
have not
was,
taken steps.
step was taken, but due to delay, service is pending in registry, Lordship.
You take precise steps.
Yes, Lordship.
Office note dated 27/10/2025 indicates, it reflects that no steps has been taken for notice. The no steps been taken for respondent number. No steps has been taken for service of notice upon respondent number 2. Mr. Swenso, respondent is granted 2 days time to take precise steps for service of notice upon respondent
Lordship,
number 2.
kindly matter may fix on 27 November.
This on 27/11, huh?
Okay, Lordship.
It is stated, it is submitted by Mr. Deloy Leonard PP that although CD was called, charge sheet has already been filed now. In view of above, let the scan copy of trial court be called for.
item number 35.
You are on bail. Yeah. We have time, but no time.
Yes.
See, what to do? Ready? If you are not ready, we'll take it after some other day.
Otherwise, I'm ready. This is a case where the prosecutor
What's the
never
offense?
examined.
4 years, 3 years.
Yes.
What is your ground?
But there's no evidence. The prosecutor was never examined. So what,
Okay.
the FIR was taken into account. That could not have been.
Acha, only FIR.
Yes. And it was corroborated with the statements who were never.
Initially, it was 376, including 376.
Yes.
Charge sheet was
No,
376.
POXO 10.
POXO 10.
Section 10. That was dropped.
Every,
No 376 matter, no penetrative section.
huh?
No indication of penetrative.
POXO 10, section
POXO
10. That
It
was
was
also dropped.
Yes.
Charges only 341,
354.
354, oh, sorry.
And 354B.
What is the basis? FIR.
Yeah.
No, no, if it's only based on FIR, when there's no examination, I mean, the prosecutor was not examined, what's this?
Vital witnesses. Take it up some other day also, otherwise I don't. Otherwise, I am ready. Otherwise.
How many witnesses? 4.
Just a moment. I think it was 6. 4.
4 prosecution, defense 4.
I will not even rely on a defense. He tried to put up with an alibi. There is no evidence in fact.
It's a short. Then in that case, very short.
Actually,
You can set aside.
there are judgments on not examining vital witnesses. It is for the prosecution. 164 could not have been taken into account. And 164 both. The magistrate has said, I did not give time to reflect. Yes.
Why you have not examined?
That is
The
the
prosecutor.
understood. The prosecutor was not examined.
Okay, I'll be.
There is no
I'll be
circumstantial
allowing the-
evidence.
Allowing the appeal, therefore we'll adjourn it.
Yes.
As agreed to by learned counsel for the parties, let this matter be listed after a week,
After 3 weeks, my lord.
after 3 weeks.
The
It's of
lordship goes to
2000
the judgment.
Okay,
All along, these are witnesses who have no connection with the cases, the incident. Your lordship will see all these statements because they have heard from somebody. He corroborates, the latter trial judge corroborates with the FIR. How is that permitted? Just cannot.
corroborated by the FIR.
FIR, yes.
I don't know,
There was another case, my lord.
the PP, learned PP will know better than
Yeah.
us.
There was another case. This is basically on imagination, man. Just imagine this.
Who is the special judge or session judge?
Session judge, special judge also, Bomdila.
2020.
Most of the cases have been interfered with by the government.